If you've been injured in an accident in Minnesota, you probably have a lot of questions. You may be wondering, do I have a case? How hard is it to win a personal injury claim? What is my case worth? How long is this going to take? How much is this going to cost? And what actually happens if a lawsuit gets filed? These are all completely normal questions. Most people in Minnesota will never hire a personal injury lawyer in their lifetime. Most people who contact a personal injury lawyer have actually never done this before. So in this video, I want to walk you through the complete process in one place. We'll talk about what a Minnesota personal injury claim is, what has to be proven, how cases are investigated, how attorney's fees work, how long cases usually take, what happens if a lawsuit is filed, and finally, my background, experience, and philosophy as a Minnesota personal injury attorney. My name is Craig Steger, and I'm a personal injury attorney practicing in Minnesota, Iowa, and Wisconsin. I've handled serious personal injury claims for more than 20 years. I want to start by talking about who this video is for. This video is for people or family members of people who have experienced a personal injury in Minnesota as a result of someone else's fault. Now let's start with personal injury. That simply means something that required medical care, caused time away from work, or created ongoing pain or discomfort. And second, it has to be because of someone else's fault, not your fault and not an act of God or nature. I'll talk more about that in a moment. Now, I want to talk about also who this video is not for. This video is not for people who have not sustained a personal injury. It is not for people dealing only with property damage. It's not for medical malpractice cases. They're a different category of personal injury with their own special rules. And it is not for people who were injured because of their own fault or maybe because of nobody's fault, such as, hitting a deer. Those situations may involve insurance questions, but they do not necessarily create a personal injury case. So what is a personal injury claim? A personal injury claim arises when someone is injured and that injury was caused by another person's fault. We usually call that negligence. In other words, someone acted carelessly and that carelessness caused harm to someone. Personal injury law is designed to do one basic thing. It assigns responsibility for injuries and provides a legal way for injured people to recover compensation for the losses that they've suffered. Those losses may include medical bills, lost income, maybe damage to property, and then the personal impact of that injury on that person's life and sometimes their family. But not every accident automatically creates a legal claim. For a case to succeed, there are certain legal elements that have to be proven. So how hard is it to win a personal injury case? Well, personal injury cases require proof. You see, insurance companies do not simply pay claims because someone was injured. Now, there are some notable exceptions to that including no-fault benefits under your Minnesota auto policy and workers' compensation. I'll talk more about those in a moment. You see, to succeed in a case, there must be evidence showing that someone else was legally responsible for causing the injury. That evidence often includes things like accident reports, police videos and photos, medical records, witness statements, photos and videos of the scene, and sometimes expert opinions, among other things. Now, the difficulty of a case often depends on several things. How clear is the fault? How serious is the injury? How well does the evidence document what actually happened? Whether there is insurance coverage can make a big difference as well. Sometimes if there isn't enough insurance, or sometimes if there's actually too much insurance, that can affect how strong the claim is. Now, I want to talk about third-party claims in the workplace. We call those work comp injuries. Now, that's one area that often causes confusion in that the relationship between workers' compensation and personal injury claims isn't always very clear. In most workplace injuries, employees cannot sue their employer directly. Instead, the law typically provides what's called workers' compensation benefits, and they're usually set by statute or administrative code. Workers' compensation typically covers medical care, a portion of lost wages, and that's regardless of who caused the accident, even if it's yourself, a no-fault coverage. Now, the trade-off for providing coverage regardless of fault is that it limits the damages that can be recovered against the employer if there's a workplace injury. This is often called the exclusive remedy rule. It generally applies to injuries caused at work, even if caused by a co-employee or the employer. Now, there is an important exception. If someone other than the employer or a co-employee caused your injury, a separate personal injury claim may still exist, and we call these third-party claims. Now, for example, imagine a truck driver who was injured by another motorist while driving, or a delivery driver who slips and falls at a business location while making a delivery, or maybe a farm worker is injured by a defective piece of farm machinery. You see, in those situations, there may be two claims happening at the same time. You may have workers' compensation benefits through the employer and their insurance company, as well as a civil injury claim against the negligent third party and their insurance company. Now, that civil claim may allow recovery for damages that workers' compensation simply does not cover. Understanding who was responsible is a key part of those cases if there's going to be a third-party claim made. Now, there are typically four proofs of negligence. First, there's a duty of care to someone. Second, someone acted carelessly or unreasonably under the circumstances. Third, that carelessness caused the accident or injury. And fourth, that accident caused real damages to someone. Lawyers often describe that as duty, breach, causation, and damages. But the core idea is the same. Someone's carelessness caused harm. A simple example might be, let's say, a driver who runs a red light and causes a crash. Running the red light is the negligent act. The collision is what that act caused, and the injuries and damages are the result. But even when someone is injured, there still must be proof. Sometimes injuries occur from accidents, but there is no legal cause. For example, imagine someone falling asleep while driving and they run off the road and get injured, or another driver unexpectedly has a medical emergency and that's the reason why they missed a red light. If no other driver or entity contributed to the crash, there may be no defendant to sue. You see, you can't typically sue yourself for your own fault. Or let's consider a driver who hits a deer on the rural highway. That may cause serious injuries, but generally there's no negligent party responsible for the deer entering the roadway. Now, we can distinguish that from a situation, well, let's say cattle escape from a farmyard or inside a fence. They wander onto the road, and then that causes an accident. Now, depending on those facts, there may be a case against the farmer or whoever caused the cattle to escape. Maybe someone ran through the fence. There are other examples as well. A mechanical failure that could not reasonably have been discovered, natural conditions like, let's say, ice in the winter forming after a storm. These events can be serious and tragic, but personal injury law requires negligence. Without negligence, there generally isn't a case. Now, if you've never talked to a personal injury attorney before, I want to kind of walk you through that process, because for many people, calling a lawyer for the first time can be understandably intimidating. You may be wondering, what am I supposed to say? What if I leave out something that's really important? Are they going to start using legal terms that you don't understand? Or are you going to be pressured to file a lawsuit right away? How much is it going to cost? Those are just normal questions. So the first step in it is usually what we call an initial consultation. In personal injury cases, that consultation is almost always free. You can talk to multiple lawyers before deciding who's the right fit for you. During that conversation, the lawyer or someone at the firm will ask you to sort of describe what happened and gather some basic information about the case. The typical things they'll want to know about are like when and where the accident happened, who may have been involved, what kinds of injuries you sustained, did you get any medical treatment, and how soon after the accident. Have you already spoken with any insurance companies or given a recorded statement? Now, as you describe what happened, the lawyer may have some follow-up questions to make sure they better understand the details. For example, they may need to know exactly where the accident occurred. Usually we need to know the state because every state has its own rules. What county, city, intersection, Which lane of travel were you in? Was law enforcement involved? If so, was it the police, sheriff, or highway patrol? That's so we know where to request documents and information. Did you receive medical care the same day, and where did you go? Did you take an ambulance? Do you know who owns the vehicle or the equipment involved in the accident? Were you already dealing with injuries or health conditions that may have been aggravated by this incident? These questions are not meant to embarrass you or put you on the spot. They're there to help the lawyer understand the facts of the case. Now, one of the first things a law firm will usually do is ask about all the people involved, including other drivers and insurance companies. Now, one reason for that is to check for any conflicts of interest. You see, law firms have ethical obligations that prevent them from representing both sides of the same dispute, or sometimes even one party if they're already represented, but representing another party involved in an unrelated matter. For example, maybe the other driver who caused the crash is going through a divorce and is represented by another lawyer in that law firm. That could present a conflict of interest. Most of the time, there probably isn't a conflict, but if there is, the lawyer should tell you right away, and sometimes they can help point you towards someone who can actually help you. Now, the consultation, that initial consultation with the lawyer's office, really has two main goals. First, it helps the lawyer and their staff understand what happened so that they can decide whether they're able to help you. And second, it helps you decide whether you want that lawyer and that law firm to represent you. If you have documents like crash reports, photographs, insurance information, maybe any medical bills or medical records, those can really be helpful at that initial consultation. Realize that you don't need to have everything organized before making the call. The consultation is simply a conversation. And now in today's age, if you prefer to meet in person or by Zoom or maybe by another video platform or phone, the lawyer should usually be able to accommodate that. It's important that you make sure that that first consultation, your first interaction with that law firm, happens at a time and in a setting that is comfortable for you. And don't feel pressured to sign a contract while you're still on the phone unless you feel very comfortable with that lawyer or law firm. Take the time to make sure that that lawyer and that law firm are the right fit for you. Now, one of the biggest questions people have is how much does it cost to hire a personal injury lawyer? You see, most personal injury lawyers in Minnesota work on what is called a contingency fee basis. That means you generally don't pay attorney's fees up front. Instead, that lawyer is paid a percentage of whatever that recovery is. If there is no recovery, the lawyer usually does not recover a fee. So what is a recovery? A recovery is simply the money that is obtained as compensation for the injuries and other harms and losses. That money can come from, let's say, an insurance payment, maybe a negotiated resolution, or sometimes a trial verdict. Now, recovery may include things like compensation for medical expenses, lost income, future medical care, your future reduced earning capacity, pain, suffering, disability, loss of consortium with your spouse, and other damages. The reason for contingency fees is it allows people to pursue legitimate injury claims without having to worry about paying legal fees out of their own pocket while you're typically dealing with medical bills and lost income. You should be given a written fee agreement to review and sign by whatever lawyer you hire. That agreement should clearly set out the fee arrangement. In many personal injury cases, that percentage is somewhere between 33 and 45%, although each case may vary one way or another. And sometimes that a fee agreement works in stages. So, for example, if a case settles before suit, there may be one percentage. If it requires a trial or maybe an appeal, that a percentage may increase. And you see, that should all be laid out very clearly in your written fee agreement. Now, I want to make sure that you understand the difference between attorney's fees and case expenses. Attorney's fees and case expenses are not the same thing. Attorney's fees are the percentage paid for legal representation. Now, case expenses are the costs required to develop and pursue the case. Examples of case expenses, let's say, are charges for getting copies of medical records, court filing fees, retainer fees for expert witnesses, deposition transcripts. In most cases, the lawyer will simply advance those costs during the case, and then they get reimbursed from that recovery later. Now, every fee agreement should clearly explain how case expenses are handled, and you should ask any questions if you're confused. and make sure that you're comfortable with the arrangement. Another concept that comes up in personal injury cases is liens and subrogation. So I want to talk a little bit about that. A lien might be a hospital lien for medical expenses. It might be a mechanic's lien if your car was repaired, or lawyers call a subrogation lien, which is where another insurance company, oftentimes a health insurance company, or maybe Medicare, Medicaid, if they paid for some of your damages, they may be entitled to reimbursement out of your recovery. And again, this should be explained clearly to you by the lawyer or law firm. Now, if you're wondering what not to say to a personal injury lawyer, let me try to cover that real quickly. Some people are worried about saying the wrong thing when they talk to a lawyer for the first time. The most important thing is simply honesty. You don't need to remember every detail perfectly, but it's really important not to hide things like prior injuries, prior claims, or prior conversations with insurance companies and adjusters. We lawyers can deal with difficult facts, what causes problems later on, or are surprises. Now, I want to talk a little bit about early case evaluation and investigation. So once a lawyer is hired, the law firm typically begins evaluating and investigating the case. This often includes things like gathering your medical records and medical bills, getting crash reports from the police officers or whatever law enforcement was there, getting insurance information, both your insurance as well as the other drivers, getting any photographs, videos, employment records if you missed work, other documentation relevant to how the accident happened and what kind of injuries or damages you sustained. Now, one of the first early steps may be sending a preservation letter to make sure that important evidence is not lost or destroyed. Depending on the case, that could include vehicle data, maintenance records, accident reports, other electronic records. Lawyers may also look for other sources of information, such as, let's say there's a business near an accident scene. Sometimes they'll have security cameras that may have captured the incident. If that footage exists, it may need to be requested quickly before it gets deleted. You see, a lot of camera systems, they simply overwrite old footage within days or weeks if no one requests that it be preserved. Now, once the representation begins, the lawyer will typically notify any insurance companies of their involvement. The insurance company is told that a claim is potentially being made and that any communication should go through the lawyer rather than directly through the client. That helps protect clients from unnecessary pressure and from confusing or sometimes one-sided conversations with insurance adjusters. One of the more important jobs the lawyer does is try to identify all potential insurance companies and policies that may provide coverage for your injuries. If your injuries are severe, it may take multiple policies to provide full compensation for your losses. Now, one of the important things that happens early on in the evaluation is to identify any important legal deadlines. That includes things like statute of limitations, which generally sets the deadline for bringing a lawsuit. In Minnesota, that deadline is typically 6 years from the date of injury, but different rules may apply depending on the facts. For example, there's a shorter statute of limitations for medical malpractice, and wrongful death claims typically need to be brought much earlier than, let's say, an injury claim. That's one of the reasons why it's really important to talk to a lawyer as soon as you reasonably can so that they can identify those deadlines and make sure that those deadlines don't get missed. Now, what's your role as the client in all of this? Once the legal process begins, your main focus should be on your medical treatment and recovery. However, there are some important things that you can do that can help your case move more smoothly. For example, make sure you continue to follow your doctor's treatment recommendations. Keep your lawyer informed of anything if anything changes. Let's say they might begin you on a new treatment, or you start seeing a new specialist, or maybe your work situation changes. If you miss more time from work than originally expected, or you return to work but with certain restrictions. These kinds of updates help your lawyer understand how the injury is affecting your health and your livelihood. You may also be asked to provide documents such as medical bills, insurance letters, or employment records, or maybe sign a medical authorization so that your lawyer can request those records directly from the hospitals and doctors. Now, clients are generally advised to avoid discussing the case publicly on social media. Insurance companies sometimes monitor your public posts and comments, and if they and can take them out of context or they can create confusions about your injury. Be sure to talk to your lawyer before deleting any posts that already exist. Now, I want to talk about how insurance works in injury claims. When people think about injury claims, they often assume there is just one insurance policy involved. In reality, several types of coverages may apply. Maybe the most obvious is liability insurance. That is the insurance carried by the person responsible for causing the accident. Liability insurance typically covers medical expenses, lost wages, and other damages caused by negligence. Property damage coverage may apply to damage to vehicles, equipment, or personal property. These claims are often resolved earlier than injury claims because the damages can usually be evaluated fairly quickly. There may also be medical payments coverage, often called MedPay. MedPay may cover certain medical bills regardless of who's at fault. This coverage typically comes from the injured person's own auto policy. Health insurance may pay medical bills while the case is pending, and when the health insurance pays accident-related medical expenses, as I mentioned earlier, the insurance company may have a right to reimbursement from any settlement or recovery. We call that subrogation. These reimbursement issues are usually addressed near the end when the case resolved and maybe there's a settlement. Now, I want to talk about no fault because Minnesota has a unique system called no fault, which applies to most auto insurance policies issued in the state or out of state if someone travels to Minnesota and is injured inside Minnesota. No fault typically provides up to $20,000 for medical expenses and $20,000 for lost wages. As the name applies, as the name implies, this coverage is available to you regardless of who's at fault, including yourself. No fault helps injured people get medical treatment right away without worrying how they're going to pay for it. Now, what is a personal injury case worth? When negligence and causation can be proven, the next question people typically ask is, what is the case worth? Damages in personal injury law usually fall into two categories we call economic damages and non-economic damages. So what are economic damages? Economic damages are the kind of the strictly financial losses caused by the injury. These are often documented with records, bills, or invoices. Examples include medical expenses, hospital treatment, therapy and rehabilitation, prescription medications, lost wages, future loss of earning capacity, future medical care, property damage such as damage to your vehicle, equipment, or maybe rental costs for getting a replacement. Now, non-economic damages reflect the intangible human impact of the injury. These losses are real, but they don't come with a receipt. You can't look them up in a blue book. They may include, like, say, pain and suffering, disability or impairment, emotional distress, disfigurement, and loss of enjoyment of life. Minnesota law also recognizes something called loss of spousal consortium if you were married at the time of the accident. This refers to the loss of companionship, support, and marital relationship that may occur when one spouse suffers a serious injury. Now, I want to talk a little bit about wrongful death claims. In tragic situations where injuries result in death, Minnesota law allows a deceased person's family to bring a wrongful death claim. Wrongful death claims are typically brought by a court appointed trustee who seeks damages for the deceased person's relatives. Those claims may include damages such as medical expenses related to their final injury, funeral and burial expenses, loss of financial support, and loss of society and companionship. Now, Minnesota law typically requires wrongful death claims to be brought within 3 years of someone's death, but no more than 6 years from the underlying accident. That's why it's important to consult with a Minnesota personal injury lawyer right away if you've lost a family member to someone else's negligence. Now, how long does a Minnesota personal injury case takes? Well, this is a very reasonable question, and if you've been injured, your life already feels disrupted. You may be missing work, treatment, you may be dealing with insurance companies, and you just don't want this hanging over your head forever. So here's the lawyer answer. It depends. Now here's the simpler answer. Generally, however long it takes for you to fully heal from your injuries, or however long it takes for doctors to determine that you've reached maximum medical improvement or a plateau. You see, Minnesota personal injury cases tend to move in phases. The first phase tends to be medical treatment and stabilization. The second is investigation and case development. The third phase is negotiation with the insurance company. And then the fourth phase, if necessary, is a lawsuit. Now, not every case reaches the fourth phase, but understanding all four of them can help you understand what's going on and who controls the clock. So let's talk about phase one, medical treatment and stabilization. This tends to be the longest part of the case. Before a claim can really be resolved, we usually need to understand your diagnosis, what treatments you require, whether surgery is involved, and whether there's going to be any permanent impairment or limitations, and if you're going to have any future treatment, when and what will be needed. If you try to resolve a case too early before your condition stabilizes, you really risk leaving money on the table. In personal injury law, we often talk about maximum medical improvement, or MMI. That simply means that your condition is stabilized enough that doctors can reasonably evaluate the long-term impact. Until that happens, it's often premature and risky to settle. The timeline is driven not so much by lawyers or courts, but really by your body and your medical treatment. So let's talk about phase two, investigation and case development. While your treatment is ongoing, the legal side of the case is also starting to develop. That may include, getting your medical records, getting your medical bills, reviewing accident reports, photos, videos, analyzing insurance policies, starting to calculate your wage loss, maybe talking to your doctors and seeing if they'll provide opinion reports or testimony. And sometimes we consult with experts such as accident reconstructionists. Now, if liability is clear and injuries are straightforward, this phase may move pretty quickly. However, if fault is disputed, or if there are multiple parties involved, or if the insurance coverage is complicated, this can just take longer. The goal of this phase is not to be quick. The goal is to be accurate and make sure we have all of the information we need to present your case either to an insurance company or to a jury. So the third phase is what we call negotiation. So often, once your medical condition is stabilized enough that we understand the scope of your damages, generally speaking, we move into the negotiation phase. That typically involves preparing a written, detailed demand package and sending it to the responsible party's insurance company. That demand package will summarize your injuries, your treatment, your medical expenses, wage losses, and talk about the overall impact that the injury has had on your life. The insurance company then reviews those materials, and that process can take some time, especially when they first receive your demand package and all of the supporting documents and information. Insurance carriers have internal procedures, supervisors, and evaluation systems. Now, some cases will actually resolve during this phase, especially if there's a policy limits demand, whereas others will require like multiple rounds of negotiations back and forth. Most cases are not seriously evaluated until your medical picture becomes clear. Now, if someone fully recovers, that case is often evaluated for resolution about 3 months after recovery, give or take. This allows time to gather the final medical records and bills. But if injuries do not resolve, doctors need to determine that the patient has reached MMI. In many serious injury cases, it may take a year or more after the accident for doctors to be comfortable saying whether someone's injuries are permanent. Once that medical picture is clear, then negotiations usually quickly follow. Now, I want to talk about phase four, and that's sometimes a lawsuit becomes necessary. You see, if a fair resolution can't be reached voluntarily with the insurance company through negotiation, we'll file a lawsuit. Now, filing a lawsuit does not mean you're going to trial immediately. Trial seldom happens less than a year after the lawsuit started, and often it can take 2 years or more before a case actually reaches trial. Filing a lawsuit simply moves your case into the court system where deadlines are set and a judge is appointed to resolve any disputes that may arise between the parties about the disclosure of information and things like that. In Minnesota, that process typically includes written disclosure of information and documents, depositions where parties and witnesses are questioned under oath. There may be motions with the court, mediation, which is often required by the court, and eventually a trial date. Trials often last anywhere from a couple days to sometimes a few weeks, although in my experience, most are completed in less than a week. Even after a lawsuit is filed, however, many cases still eventually settle. So, what makes cases move faster? There are a number of factors that tend to shorten that timeline. If there's clear liability, if the injuries are obvious, like broken bones and those that require surgery, if there's clear and predictable medical outcomes, if there's, let's say, adequate insurance coverage, and if you have cooperative parties, insurance companies, and lawyers can help. Now, on the flip side, there are things that can slow down the process. If your medical treatment takes a long time, if fault is in dispute, if there's multiple parties involved or multiple injured parties, if there's insurance coverage that's limited, unclear, or sometimes too much insurance can slow down the process. If the parties have to stop and hire experts or coordinate inspections of vehicles and things like that. Sometimes, depending on the county where the case is filed, the court calendar can be fairly busy. There's just a lot of structural realities into the process that can impact how quickly the case moves along. These are not necessarily signs that something is wrong with your case. Generally speaking, the more serious the injuries, the more preparation that's required to get that case ready for meaningful resolution and trial. Now, I want to talk a little bit about the settlement phase. So, once medical treatment has progressed enough to understand your injuries, the case usually moves into a settlement phase. I already mentioned, a demand package is sent to the insurance company. Also, during the course of a lawsuit, the judge may require the parties to come together and have what's called formal mediation. That's often done with a retired judge or an experienced civil trial lawyer who will serve as a neutral party and try to see if they can help the parties get the case settled. You see, after a lawsuit is filed, most cases do eventually settle before a jury trial. Now, a good personal injury lawyer needs to prepare every case as though it may eventually be presented to a jury. When insurance companies see that a case has been investigated thoroughly and prepared seriously, it tends to lead to more meaningful settlement discussions. Insurance companies tend to know if a lawyer or law firm is afraid of going to trial. There are typically 5 steps of an actual lawsuit once a lawsuit has been started. The first is what we call filing the summons and complaint, and then that gets served on the other party, and sometimes their insurance company by the sheriff or a civil process server. The second phase of a lawsuit is typically what we call discovery. I mentioned that a little earlier. That's where both sides exchange documents and information, and sometimes take depositions of witnesses. The third phase is what we call pretrial motions and mediation. Sometimes there's an important legal issue in the case or regarding a particular piece of evidence. The parties need the judge to decide before, let's say, they can meaningfully try to settle the case or go to trial. In the fifth phase, if the mediation is unsuccessful, is trial. And if that is unsuccessful, there can actually be an appeal if either party is unhappy with the result. Most cases, I would say, actually resolve during discovery or at mediation before any trial actually happens. Now, I want to talk a little bit about comparative fault. Minnesota uses a comparative fault rule. That simply means that if an injured person is partially responsible for an accident, damages will be reduced in proportion to whatever fault that person has. Let's say, for example, you're 30% at fault. Your damages, whatever they are, will generally be reduced by 30%. However, if you, the injured person, the plaintiff, are more at fault than the other party, your recovery may be entirely barred. If a case goes to trial, the jury will generally be asked to divide up fault among all the responsible parties, equaling 100%. Though that rule can have a major impact on how cases are evaluated if the parties dispute who has the majority of the fault. I want to talk a little bit about the communication process in a personal injury case, especially if you haven't been through this process before. That's going to include updates from the lawyer or someone in their law firm about developments in your case. They'll provide you with an honest evaluation of the case, and they should be able to answer any questions that you have along the way. Now, there may be periods of time when things seem quiet, like when you're going through medical treatment, or maybe the parties are waiting for the court to schedule a hearing. That's normal. Your lawyer probably has a team of people helping them with your case. That might be other lawyers, paralegals, legal assistants, and they can usually help answer questions that you have and keep you updated even when let's say, your main attorney assigned to your case is not immediately available. You see, most cases go through phases, with some stages busier than others. When I'm preparing a case for trial, that trial becomes the focus of my attention. And eventually, when your case gets ready for trial, your case will be the focus of my attention. Now, some people wonder, when is it really necessary to hire a lawyer? Now, a lawyer may be helpful if you have injuries that are serious, if liability is in dispute, if there's multiple parties or insurance companies involved, or the insurance coverage is simply complicated. But not every minor accident necessarily requires a lawyer. But usually, serious injuries often benefit from having a lawyer and a legal team helping you. It's also important to know that you're free to speak with more than one attorney before you decide which one to hire and which one is the best fit for you. As I mentioned earlier, that consultation with a lawyer's office should be free. This allows you to ask questions, understand your options, and choose the attorney or law firm that you feel most comfortable working with. Once you actually choose a lawyer, you'll sign a written fee contract, and in many cases that can actually be done electronically if you prefer not waiting for the mail or coming into the lawyer's office. If you're considering hiring a personal injury lawyer, it is completely reasonable to want to know who you're dealing with. When you hire a personal injury lawyer for a serious injury case, you're trusting that person with something really important. So let me tell you a little bit about my background, my experience, and how I approach injury cases in Minnesota. I was born on a small dairy farm in northeast Iowa. Later on, my family moved to South Dakota and we operated a large beef ranch. Today, I live on a small farm in western Wisconsin with my wife and our 9 children. Farm life teaches you certain things early on: hard work, resourcefulness, and that the work isn't necessarily from 9 to 5. You work until the job is done, whether you feel like it or not. And you learn that results don't come from shortcuts. They come from being prepared and being consistent. You see, that background shaped how I think about legal work and how I approach cases and how I help my clients. Now, why did I become a lawyer? You see, law wasn't my first plan. I actually originally planned to become a priest, and I studied for that for 3 years in Winona, Minnesota. When I decided to leave that path, I still had a strong desire to help people and do work that mattered and was challenging to me. It was actually a priest friend that recommended that I consider law school, and that turned out to be some of the best advice I've ever been given. Personal injury law, in particular, allows me to help people during some of the hardest and most difficult times of their lives. It's not actually about arguing so much, it's more about listening and preparing and understanding how the facts all fit together with the law, and then presenting those facts clearly in a way that a judge or a jury or maybe an insurance adjuster can understand. I'm a civil trial attorney. That means I prepare each case as if the case may ultimately be presented to a jury. Not every case goes to trial, and in fact, most cases do not. But the possibility of trial shapes how a case is prepared from the beginning, and insurance adjusters can tell whether a lawyer is actually willing to take a case to trial or whether that a lawyer will eventually cave. Knowing that your lawyer will take a case to trial when necessary is one of the biggest factors in getting maximum recovery for your injuries. Over the years, I've handled a range of serious injury matters. My practice focuses on injury and civil litigation matters that includes car accidents, commercial vehicle and trucking cases. I hold a Class A commercial driver's license and I still drive truck when I get the chance. I handle farm related injuries and other serious injury claims where liability and damages may be unusual or complex. Now, my courtroom philosophy is this: I approach court in a very straightforward manner. I try to prepare thoroughly from the very beginning of the case until the end. I try to be honest and transparent with clients, judges, and jurors. I try to present the evidence clearly and to respect the intelligence of the jury and my judge. Try to avoid exaggerating things, and I try to not pursue claims that I don't think can be won. Because of my background, I understand in a special way rural life and working communities. I understand the realities of physical labor. I understand what it means when an injury affects your ability to work with your hands. I understand how difficult it can be to pay the bills when you cannot work. I understand and appreciate the importance of being able to play with your kids and attend their activities. That influences how I communicate with my clients. It influences how I evaluate my cases. It influences how I prepare them. Now, I'm licensed in Wisconsin, Minnesota, and Iowa in both state and federal court. In Western Wisconsin, Southeast Minnesota, and Northeast Iowa, people regularly travel across state lines for work, pleasure, and just everyday life. That gives me the flexibility in handling cases that sometimes involve multiple states, and it helps me choose the court system that best fits the needs of my client. When someone contacts my office, I try to listen and gather as much information as I can about their case and what matters to them. I try to give my honest opinions. I try not to sugarcoat things, and I try to make sure my clients understand their options so that they can make informed decisions. I want clients to believe that I am the best lawyer for their case if I am. If I don't think I'm the best lawyer for them, I'll try to help them find someone who is. I'm not a volume-based operation. You probably won't see me on any billboards or gas at the gas pump. I'm not interested in quick settlements unless they reflect the seriousness of the injury. I use my experience and my firm's resources to try to work every client's case the best possible way. If you've made it this far, here's the big picture. A Minnesota personal injury claim follows a pretty consistent structured process. It starts with figuring out whether negligence can be proven, then documenting those injuries and damages, then understanding the insurance coverage involved, and allowing enough time for medical recovery and doctors to determine the long-term impact of your injuries. Then I negotiate seriously, and if necessary, will file suit and bring and prepare that case for trial. At the same time, if you're considering hiring a personal injury lawyer, you should know that the first consultation should be free, that conversation should be confidential, and you're free to talk to more than one attorney before making a decision. You should understand how contingency fees work, how costs are handled, and what your lawyer's communication style and approach will be. Most of all, you should make sure that the lawyer you hire is someone you trust to handle something really, really important. These cases are not just about paperwork, they're about your health, your work, your finances, your family, and your future. If you're in that situation, take your time, get informed, ask questions, and make the decision that is right for you and your family.